Kevin mentioned I'm going to speak about the position in Ireland. I am, but I'm also going to look at the wider international perspective, if that's okay by you. Essentially what I'd like to do is very simple, just present a report to you. I know most of you are very familiar with the developing law in this area, but one has to be, attentive all the time, and you may have seen that there was an important decision from the European Court of Human Rights just yesterday. So this is a story that is unfolding with a kind of an increasing speed, I think it could be said, in terms of the cultural transition that's taking place internationally. Just like to tell you what is happening there to remind you of the legal developments in broad brush strokes internationally. And then just say a few words about human rights, the role of the European Court of Human Rights, and just generally my perspective on how human rights operate optimally in the context of the themes we're talking about. And just picking up on both what Kevin and Alex said, I think it's entirely fair to link the concepts of euthanasia and assisted suicide. It would be possible theoretically to have an entirely different perspective on both those themes, on each of those themes. But it is entirely, philosophically and logically a possibility. Yet, from the position which I'll be mentioning to you internationally, in terms of legal developments at least, it's quite plain that in the minds of courts, the two issues are integrally related, and they are ultimately concerned with the underlying values, societal values in respect of society's understanding of the importance and significance of life, and they impact both in the area of euthanasia and assisted suicide. Broadly speaking, as Alex mentioned to you, you understand the traditional position was that euthanasia was and generally is in most countries unlawful on the basis that it does involve taking another person's life. In the area of suicide, suicide itself used to be an offence in many countries. It was an offence in Ireland until 1993. And around that suicide, attempted suicide, it was possible in principle to prosecute for attempted suicide. And it's possible and continues to be possible to prosecute for assisting in suicide. Now, I think most humane societies today recognise that the idea of prosecuting for assisted suicide is unacceptable in terms of the extra pain that it would involve to a person who has already attempted to take their own life. And that explains and indeed was the basis for the removal of the criminal sanction in 1993. That did not involve a creation of a right to take one's own life, but rather it was the removal of a criminal sanction against those who had unsuccessfully attempted to take their life, based on notions of humane concern for people already in situations of difficulty. Let's just talk a little bit about the concept of euthanasia in the Irish dimension. It is contrary to the law, and the Supreme Court has consistently said that euthanasia is and continues to be contrary to the law. There was a case, as many of you know, in 1995, the Ward of Court case in 1995. That case concerned a person, a woman, who had been a young woman, but as the years had gone by, she obviously had, the years had gone by on her, and she had been in a situation where her condition was not that of a persistent vegetative state or permanent vegetative state, but rather a person who retained some degree of cognition and emotional response. And after several years, members of her family sought to have the feeding system, which was a peg feeding system, removed from her. That case went through the courts slowly. It was decided by the High Court in favour of those who were applying to have the feeding removed, and then on appeal the Supreme Court came to the same view with one dissenter. And essentially the way the Supreme Court understood the law to operate here is that this was not a euthanasia case, but this was rather a situation of, as it were, letting nature take its course. They characterised the provision of feeding through a tube as constituting medical treatment, and their view was that it is not necessary to continue medical treatment if the medical treatment is not conferring a benefit on the patient concerned. That was the structure of thinking which they adopted. It echoes the Tony Bland case, which had been decided in Britain relatively recently before that decision. Now, there are We can have a discussion about that, perhaps we will later. Those who criticise the decision say that, in fact, to characterise the provision of feeding to an individual as medical treatment and to treat the medical treatment as futile or not conferring a benefit, that actually does involve very considerable philosophy. It means that the normal human solidarity of feeding people and keeping them nourished is now medicalised, and the medicalised characterisation then is treated in isolation as does it confer a benefit on the patient concerned. And to say that continuing to feed somebody does not confer a benefit on that person actually does involve a very significant existential understanding of the significance of life. Sounds like medicine, but actually it involves a very considerable view. And in essence, the view is that the continuation of life for a person in those circumstances, with some degree of limited cognition, is not to that person's benefit, and it is appropriate that that person's life be ended. That is essentially what the Ward of Court case decided. Just yesterday, the European Court of Human Rights had a somewhat analogous case. The person in question, he was a man who had been involved in a traffic accident. A number of years had passed. The human facts are, very important, and one shouldn't, just understate them. His wife was of the view that the feeding equipment should be withdrawn. The man's parents were of a different view. It had gone through the courts in France, and summarising it very briefly, the appellate court in France took the view that it was appropriate to have the feeding removed. The European Court of Human Rights, by a majority, followed the same view. So it is somewhat similar, certainly in its conclusion, and somewhat similar in its analysis to the Irish Supreme Court decision. There was a strong dissent in that particular case. That is on the, what you might call the euthanasia stroke withdrawal of feeding category of thinking in this area. And the European Court of Human Rights, just like the Irish Supreme Court, said this is not a euthanasia situation. They characterised it as the withdrawal of futile support. To oppose that would be, under the French law, regarded as obstinate refusal. And they accepted that the French legal system was appropriately applied. When we come to assisted suicide, situation is somewhat different. Situation is that here we're dealing with, obviously, the question of the person's autonomy, and also the question of whether continued life would constitute some form of invasion of a person's privacy, or more radically, inhuman treatment in respect of that person. There has been litigation, as you know, in Ireland in this area. The Fleming decision was decided 2 years ago, and the Supreme Court, affirming the High Court, held that there is not a right to assisted suicide in Ireland. They held that it is appropriate for the legislature to come to the conclusion that the protection of vulnerable people would justify a complete prohibition in this area. But what's important about the Supreme Court decision is that it did not say that the legislature must so conclude, and there is a paragraph in it which is somewhat Delphic, but indicates that if the legislature were to come forward with another piece of legislation in this area, clearly modifying the absolute prohibition on assisted suicide, the court would look at it and scrutinise it in the light of constitutional values. So I think, when we're speaking more frankly, the court gave an indication that it was not necessarily averse to legislation on this particular issue. Now, that approach reflects the approach that had been adopted in Canada in the Rodriguez case in 1993, by the American Supreme Court case in a couple of decisions at Luxembourg and Vaco and Quill back there in the 1990s as well, in 1997, and indeed reflected what the European Court of Human Rights has been doing in a series of decisions, including a case called Pretty, and then a couple of other decisions involving similar types of issue in the European Court of Human Rights, essentially saying that the rationale based on concern that if one introduces some degree of legal entitlement to assisted suicide, this is going to expose vulnerable people to danger of exploitation, danger of regarding their own lives as being a burden on others, pressures that do not exist in circumstances where the absolute prohibition exists. And then also, as Alex was mentioning too, the implications for the medical profession in terms of medical professions holding whole tradition having been to do one's best for one's patient, to continue life, to maintain within the bounds of reasonableness, within that long traditional distinction between ordinary and extraordinary treatment, which is absolutely at the heart of medicine, and I'm sure we're going to hear more about it today, to turn doctors from that type of vocational relationship with their patient into a different type of vocational relationship with their patient, with, as one can appreciate, radical implications. Now, if you look at those decisions, well, one should mention two further developments. One development is that in England, which has had a certain amount of litigation, which has finished up in Europe in a number of cases, notably the Pretty decision, relatively recently, in 2014, after the Irish decision, there's a case called Nicklinson, and in the Nicklinson case, the UK Supreme Court did uphold the ban on assisted suicide, criminal prohibition, which is expressed in terms identical essentially to those in Ireland. But there were indications from a number of members of that court that this is a matter that would benefit from being revisited by the legislature, and the court would, as it were, engage with the legislative response. In other words, there was an element of engaging the legislature to look again at this decision. Certainly, that would appear from Lord Newberger's decision. He certainly stressed that element, that this was not, as it were, a final decision on the matter, and it was a matter open for review at a later stage. More recently than that, we've had a decision in the Supreme Court of Canada, and just earlier this year, and from the standpoint of international legal developments, this is of very crucial importance, because the Supreme Court of Canada took on all the arguments that had been expressed in all those previous decisions in the United States, in its own earlier decision in Rodriguez, in the Irish decision, in the European case law dealing with assisted suicide. And essentially, all of those decisions had, up to that point, said that a legislative total ban based on concerns for protecting vulnerable people and concerns for the medical profession and the integrity of the medical profession, such a legislative ban was not inconsistent with protection of constitutional rights or human rights under Charter or under the European Convention. All of the decisions, therefore, had countenanced the possibility that the legislature could say no to assisted suicide. But this is the first decision which says the legislature cannot say no to assisted suicide, because the Supreme Court of Canada decision held that in the light of the Canadian Charter, which is a document not dissimilar to the European Convention and not entirely dissimilar to our own Constitution, though somewhat differently written, but the point, essentially the value point, is the same. The Supreme Court of Canada said that in the light of the entitlement to one's liberty interests, a complete ban on assisted suicide is inconsistent because it is overbroad. It does do valuable things, which is to protect, as I say, protect the vulnerable and protect the medical profession, but it does so at a price which is that of being of overbreadth, that it captures some people on whom that policy is going to weigh too heavily. And the court took the view, echoing what the trial judge had said in British Columbia, the court took the view that it can be done. A legislative framework can be presented which will deal with concerns about exploitation. And they gave the Parliament a one-year period within which to bring in this law. So that's a very radical case, and unquestionably that case will be cited, in jurisprudence, including in Ireland. The earlier case, that's to say the case at trial level, was cited in Ireland. It had been decided at that stage, but didn't have the same impact, as you can appreciate, that a Supreme Court of Canada decision would have. So this, certainly, I would regard that decision from Canada as highly significant, as being the first decision which actually said it is possible for legislatures to formulate legislation which will protect the vulnerable. Now, critics of the Canadian decision, not surprisingly, have said you've offered no basis for this confidence whatsoever. It did not get itself immersed in the empirical evidence, which Alex touched on there, other than to say that the trial judge could reasonably have come to the conclusion that she did. It made distinctions with the Belgian situation, which are I think most people reading the decision would feel are somewhat unconvincing. But the bottom line is the court did decide what it decided. And that means that when we come back to Ireland, and this issue is going to be debated, obviously, in forthcoming weeks, months and years, the question is going to be, is it possible to produce legislation which is capable of protecting the concerns about vulnerable people, whilst at the same time focusing on the individual concerned? I have to say that I would be on the side of the critics here on the basis that the Supreme Court of Canada offers no basis for assuming that this task can be done by legislation. Again, there's an emphasis on procedure in terms of getting signatures, getting conclaves of medical people to come together and make a decision. At the end of the day, the difficulty of making a decision and the difficulty of being able to, as it were, assess the totality of an individual's life on the basis of these forms of short scrutiny. I think realistically we all know that from our experience that medical engagements would not be infallible in this area. And the implications would be people who would never be necessarily seen, as it were, or come before the scrutiny of doctors. Just like to say a few words about the European Court of Human Rights situation in the next 2 or 3 minutes and then finish. I can look Kevin in the eye. I'm absolutely a supporter of human rights, and I imagine all of you are a supporter of human rights. Human rights as meaning that inhering in every person there's an inherent value of equality with everybody else in the room, everybody else in the world. That this is something that cannot be taken away from us by law, that it is part of our very human nature. It is what we are and what we are, if you like, our inherent value. Every single human being has unique, deep value. We recognise the constructs of human culture in Syria which have been taken down, and we realise the violation that involves. We can see that immediately on the basis of the precious worth that the human enterprise is concerned with. Yet every single individual contributes to the totality of that wonderful worth, which is humanity. And that is what human rights, I think, properly understood, are concerned with, which is the unique wonderfulness and worthwhileness of a human life. Respecting autonomy, respecting bodily integrity, respecting health, and demanding that society live up to its obligations of solidarity with those who are in a vulnerable and needy situation. What I'm concerned with in terms of human rights as applied by courts, and specifically the European Court of Human Rights, is that the European Court of Human Rights understandably has a very significant political dimension because it's dealing with so many countries. And the European Court of Human Rights has adopted, under the language of this human rights discourse, has adopted criteria which manifestly cannot be reducible to or ascribable to a human rights philosophy. I will just simply mention the notion of consensus, and that could become important in the area we're dealing with here. The European Court of Human Rights works on the basis of significant regard to consensus. That is to say that if a particular cultural shift takes place within Europe on a particular issue, and that a significant number of countries adopt a particular value position, the European Court of Human Rights view is that that consensus must translate then into the articulation of a right. Now, I'm not saying that automatically, because there's a consensus, there's automatically a right, but the court gives very significant weight to the concept of consensus. So that is a form, as you can understand, of what you might call legislation through the European states, each one of the European states. When sufficient number of them legislate in a particular way, those countries which do not adopt the same value position are told, sorry, you must. Now that may be good in terms of European solidarity, or bad. It may be politically necessary. It may be politically, pragmatically desirable. Of course, it's all perhaps of those things in the eyes of the court. But whatever it is not human rights. Human rights are not decided by votes. We know that. And that is a direct contradiction to the understanding of the philosophy of human rights. It also involves positive law imposing itself in circumstances where a value system of human rights says this is unacceptable conduct. So I just mentioned that in the context, I'm just going to wind up now, but just mention that in the context of human rights discourse. There are human rights, and there are human rights as interpreted in a positivistic way for pragmatic reasons. And I think what we should do, certainly in forthcoming weeks, months and years, is adhere to genuine human rights and assert the absolute wonder of each human life, its inherent value, and the solemn obligation resting on our society to be fully conscious of the worth of every human life. Thank you very much.